Hello and welcome to today's webinar, How the Court Can Address Safety and Economic Security for Victims of Violence Against Women, hosted by Wider Opportunities for Women. My name is Mallory Dusenberry, and I am the Associate Director for the Economic Security for Survivors Project here at WOW. First, I would like to do a little housekeeping. Your lines have been muted to ensure that background noise does not interfere with today's conversation. If you have tech issues or questions during the presentation, please use the meeting chat located in the bottom left corner of your screen. At the end of today's discussion, you will have the opportunity to ask questions over the phone, and you may submit questions throughout the presentation over the chat function. We will send out a recording of the webinar along with the PowerPoint slides and any relevant resources later this week. The purpose of today's webinar is to outline the unique role of the courts in keeping survivors safe through economic security and to offer specific strategies that judges and other court staff can use to accomplish this. Following a discussion with our expert judicial panel, we will introduce WOW's latest tool, the Court's Guide to Safety and Economic Security for Victims of Violence Against Women. For those of you who are new to us today, Wider Opportunities for Women works both nationally and locally in Washington, D.C. to promote economic independence and equality of opportunity for women and girls. For 50 years now, WOW has helped women with programs emphasizing quality jobs, gender equity, and lifelong economic security. To accomplish these goals, WOW engages in national policy advocacy, technical assistance, and research initiatives. The Economic Security for Survivors Project recognizes that survivor safety and economic security are inextricably linked and promotes strategies that foster economic security within the systems that serve survivors. The S Project provides resources, education, training, and technical assistance to transitional housing programs and other direct service providers, state and local governments, domestic violence and sexual assault coalitions, and VAWA's Stop Grant program. Our activities include on-site state trainings, guides and policy briefs, webinars and curricula development, and a monthly newsletter. I am joined today by Robin Thompson, who serves as WOW faculty and greatly contributes to the S Project products and trainings with her experience as an attorney and former STOP administrator in Florida. Our wonderful panel includes the Honorable Lynn Tepper, who has been a circuit judge in Florida's 6th Judicial Circuit for nearly 3 decades. Judge Tepper sits in Dade City presiding over all the dependency, SINs, FINs, and crossover cases for the families before her, as well as all the domestic violence injunction cases in East Pasco County. Her court is one of the 6 sites in the U.S. implementing Project One, NCJ-FCJ's One Family, One Judge program. She has served in virtually every Florida bar or Supreme Court committee involved with children, families, and domestic violence, and led the governor's domestic violence clemency review panels. Judge Tepper also teaches and speaks nationally and statewide. She is joined by the Honorable Steve Aycock, the judge in residence for the Family Violence Department of the National Council of Juvenile and Family Court Judges. Judge Aycock previously spent 9 years as the chief judge of the Colville Tribal Court for the Confederated Tribes of the Colville Reservation, and 12 years as the director of the Colville Tribal Legal Office. He has also worked for Evergreen Legal Services in the Pasco, Washington office, and as a public defender in Franklin County District and Superior Courts. Judge Aycock has taught at the University of Idaho College of Law and has presented at law schools and judicial conferences across the country. So before we launch into the discussion with these 2 judges, I want to give a quick overview of why we're talking about economic security for survivors. Let's start by defining what is economic security. One must, of course, be able to earn enough to cover basic needs and daily expenses. However, economic security goes beyond basic self-sufficiency. It also requires having the finances to protect one into the retirement future and from unexpected events such as a violent attack. As a result, WOW defines economic security as having the income, assets, and access to services to meet basic needs, as you can see here, participate in the workforce, and build savings over the lifespan. WOW has calculated what one needs to earn to be economically secure across the country and down to the county level for up to 420 different family types. We found that economic security wages are far above minimum wage and at a level far exceeding the poverty line. For example, a single worker needs to earn about $14 per hour, and a single parent with 2 kids needs $27 per hour. For those single parents, the largest expenses are childcare, housing, and transportation. which are also the 3 largest economic barriers cited by survivors as well. WOW also compares the best numbers to actual labor market data and finds that 45% of all Americans live without economic security. In addition, in part due to childcare cost discrimination and a lack of good jobs and support systems, 60% of single women and 81% of single mothers are earning economically insecure wages. Economic security becomes even more important for survivors of domestic violence, dating violence, sexual assault, and stalking, who may have greater economic needs. The economic cost of violence can include job loss, unfinished education, eviction, loss of personal property, and expenses related to health care, relocation, and security measures. For example, rape can cost victims more than $145,000 in health care, lost wages, and justice system participation costs over the lifespan. Offenders also often perpetrate economic abuse as a tool of power and control and to create dependency. It can involve controlling finances, compromising credit, identity theft, interference with employment, and even coercing a survivor into crime. Many of these are also crimes in and of themselves. These 2 impacts combine to create barriers to survivors recovering, staying safe, and achieving independence. For example, shelters reported that 74% of survivors stayed with an abuser longer due to financial issues, and nearly 75% of survivors indicate that they have trouble paying their bills or are one unexpected expense away from hardship. In addition, state fatality reviews often find that the parties were unemployed or undereducated and that the victim was unable to leave due to economic needs. So while there are both overlaps of both occurrence and the economic impacts between intimate partner violence, sexual assault, and stalking, there can also be very clear differences, which changes how systems can respond. For example, dependency issues are much more common in intimate partner violence cases, and sexual assault may be perpetrated by a coworker or supervisor, thus resulting in unique impacts upon employment. So due to the wide-ranging economic impacts of violence over the lifespan, it's essential that survivors receive the help and support that they need to stay safe and economically secure. Survivor economic security is not just the role of direct service providers, although they do provide a critical role. The justice system and other sectors also have key roles to play. For example, without the justice system, there can be very little protection from future or additional harm or crimes. There can be very little connecting to some resources or recouping economic losses. So on that note, to explore what the role is specifically for the courts, which is why we're all here today, I'm going to turn it over to Robin Thompson and our guest speaker. Let me go ahead and pull them up right now. Robin, can you hear me?
Okay, yes. Can you hear me?
Yes.
Okay. All right. Good afternoon, everyone. It is an honor to be with you today and to be with Judges Tepper and Aycock to talk about this really important issue. We're going to have a discussion amongst us with the judges taking the lead on discussing some key questions. These may be questions that you have in mind already as you're starting to think about this issue or as you've thought about this issue in attending this webinar. But if not, remember, we will have time at the end of this program for you to address your questions. So I'd like to move to the very first question and open it up to a discussion. And Mallory, okay, there we go. Thank you. And the first question we want to talk about is how this issue of survivor economic security or relative insecurity impact the work of the court. And I know that both of you have had experience and both of you have information that you can talk about in terms of court efficiency, financial issues, just basically how this issue impacts the work of the court. Who would like to start?
This is Steve, Judge Aycock. Okay. I'll go ahead.
All right, Judge. Thank you.
Sure. The most important thing is that the whole protection order and sentencing is about victim safety. And we always have to keep that in the back of our heads, that that's really what we're trying to accomplish, as well as better accountability. And if, in fact, we're talking about safety, then we need to recognize that economic insecurity is a direct threat to victims' safety. it can impact their ability to even participate in the system. If you think about, you have to go to the courtroom, the courthouse, to get a protection order. If you don't have any money, if there's no private or public transportation, if you have children, these are all barriers, and you don't have any kind of child care, these are all barriers to actually just getting to the courthouse to even start the process. It also, economic security increases justice. Again, we have to look at what is the total damage that was done because of the violence by the perpetrator. And that is much more than just restitution for any kind of physical damage. There's all of the other kinds of controlling behavior that occurs. And so when we start looking at what those other things are, have you been isolated? Does he do all of the finances? All of that then, if we take that into account, can increase justice for victims. It also increases offender accountability because they realize then that the damage they have done is much more and much greater than just whatever physical harm that they may have caused. It could lead to trust or increased reporting. Once victims in a community have trust in the system, you can expect that your numbers may actually go up because more people are coming forward. I mean, we need to recognize that about 25% of DV victims report, so that means 75 are not. Only about 20% of rape victims, 50% of stalking victims, and only about 20% of those get a protection order. So to the extent that victims know that when they go to court they can become whole and that they can become safe and that they won't need to go back, then they're more likely to come forward and try to use the system to help themselves. Also,
sorry, go ahead.
No, go ahead. I was one more thing was just, if you do this, it may also decrease filing. So a victim who comes in and gets a protection order but doesn't get any kind of economic relief, or at least not sufficient economic relief, may feel the pressure to have to go back to the batterer because that's where their economic security lies. That means that over time, that person is likely to come back to the court again, and maybe again and again. So to the extent that courts can provide that economic security, they don't have to keep coming back to the court to try to be safe.
And that's where I want to follow up by talking about the primary level at which it impacts the work of the court. This is Judge Lynn Tepper. And then the secondary level. Just as Judge Adcock was just speaking about repeated filings, I'm sure that the judges that are participating have had the experience of seeing the same faces over and over again in various divisions of the court, sometimes in the same division. It is not unusual in a domestic violence injunction request to have frequent voluntary dismissals before the court has an opportunity to hear the case. I know that in the approximately 26 years I have been involved in domestic violence injunction cases, the percentage of individuals that actually appear petitioners in court has significantly increased as they, I believe, saw what the judge was just mentioning, and that is that the courts are being responsive. So they have a shot at getting something that will allow them to remain safe and economically secure from the respondent. As you have no doubt seen, even if there are voluntary dismissals, the cases get refiled. The next act of violence results in another refile. And, of course, these parties are also filing domestic relations cases such as dissolutions of marriage or paternity actions. those end up getting voluntarily dismissed or abandoned when there is no economic security and a victim finds no alternative but to go back to where they have a home, where they have a place where the children can register for school and go to school, catch the bus. And, of course, whenever there is public assistance, whether somebody has a case open or not, the federal government will see that the Department of Revenue in the state of Florida, but that there is some requirement that an individual who gets food stamps, any form of public assistance, must cooperate in seeking child support from the non-custodial parent. Those cases repeatedly end up being abandoned because the respondent can't be located, or they are abandoned or dismissed voluntarily because the Department of Revenue, or whoever is pushing the case, finds that the parties have reunified. They've reunified, no doubt, because there was no confidence that there could be economic security, and the parties have gone back together. And, of course, we will see on a primary level repeated criminal arrests and filings that often end up with the prosecutor's office filing a dismissal at the time of trial, because we have victims who may not show because they lack the financial resources that were just referenced, or they're afraid because they have no financial support, or the state has simply decided not to file. There is also the criminal violations of domestic violence injunctions that are repeatedly arrested, where if the courts have not adequately responded from the beginning on a domestic violence injunction protection order, to have economic assistance, to have periodic reviews, to make sure that children are safe, as well as a petitioner, then the parties tend to do their own informal modifications, and people are repeatedly arrested for violation of the injunction. And then, of course, you have escalating domestic violence. I know that I have found over the many years of looking at all related cases of families, which I see every time I have the cases, I will see that where there was a domestic battery that either resulted in a sentence where there was no batterer's intervention program, no financial support, chances are we're going to have several more batteries over time. And if we don't have protection, because we have a victim who feels they have no financial support, they have no support, that what their needs are not being met by the court, then the violence only gets worse, and we see them escalating into domestic violence on a pregnant victim, aggravated batteries, domestic violence by strangulation, even arsons and attempted homicides. And, of course, we see them in yet another division of the case, and that is a dependency or child abuse, abandonment, and neglect case, where there is a failure to protect either from the petitioner isn't protecting from another parent or from a paramour. And, of course, we do have that secondary level of impact on the courts, and that is the children. We know that children that are growing up in violent households are going to be in our dependency courts as parents themselves one day, because of the frequency of premature teenage births, because of truancy, because of delinquency. They become our youthful offenders. They are parties themselves in all of the very cases that I just mentioned. Having done this now 30 years, I'm on my third generation, and I see the failings of the first generation by not making sure there's economic security has resulted in this secondary level of impact on the court.
Thank you. Thank you. You know, you both have raised really important issues that undergird this whole project, which is, number one, the mantra that we're trying to share with everyone, that economic security equals safety for victims of stalking and sexual assault and domestic violence and dating violence, and also that being aware of this really helps you do your jobs better as judges. It helps the system move more effectively, and it helps promote the better and fair administration of justice. So this is great. Thank you. These are great comments, and you both are right on. The next slide, we really want to kind of get into a little bit more of the nitty-gritty and talk about steps that judges can take. We've heard, as we've worked on this project with prosecutors and with law enforcement and with advocates and people in the field, and indeed we've heard it from judges that, they can't get too involved in this issue because if they talk about this issue or if they move forward too strongly, that they will leave the impression of being biased in favor of the petitioners or of the victims. Steve, you want to start us out, or Judge Aycock can start us out a little bit on talking about protection orders, and we can move into and then a further discussion of those. And by the way, before you start on that, this is in the realm of the STOP grant program, which mostly does address criminal matters. Clearly, there's room in the STOP administration of all the funding that we get under STOP to look at violations of protection orders, as well as other issues that kind of go back and forth between the criminal and civil side. So that's why you'll hear us on this call talk about the civil side as well as the criminal side. There is just a back and forth flow, even though STOP mostly does deal with the criminal side. But let me turn it over to you, Judge Aycock, to talk a little bit about some steps that judges can take in terms of protection orders and how, overall, looking at this issue of how to remain unbiased.
Sure. And one of the things I think is really important for everyone to realize is that when the judge gets to the point where they're going to actually start giving relief, there has been some level of adjudication that relief is necessary. And so it's hard for me to understand how somebody could say the judge is biased after they've already determined that there's been violence and that the respondent is the perpetrator. And now we're going to try to make the petitioner whole subject to whatever the local statute is. And it's really important for judges, both civilly and criminally in protection orders, to know the statute and the case law in your jurisdiction. And the reason is because you really need to know what is the maximum relief that you can give. And remember that we're talking about trying to get victims to safety. So I've had conversations and trainings with judges where sometimes when you ask them, can you do X in terms of giving some sort of financial, they're not quite sure if the statute allows them to do that or not. So it's really important for judges to know exactly what kind of economic relief you can give. And even if that's only temporary, so for instance, if there's children involved and there's a protection order and your state requires the petitioner to actually go file something in domestic relations court to be able to get a permanent custody and child support order, if you can offer that on a temporary basis, it still should be awarded. Just think about what happens then if I have to go to domestic relations court. I mean, I come to you to get a protection order. I'm not given full economic relief because there's no child support that's going to be given, I'm told, even though the statute may allow it. I then have to go and I have to file. There may be some kind of waiting period. There may be some requirements to go to a parenting class or a divorce class. It may be some time before you can actually get a temporary order out of the court. All of that time, the economic pressure increases for the petitioner, and one way to relieve that continued pressure is to go back to the respondent. Also, make sure if you have a catch-all section of your law that you use it. And generally those catch-all sections say something like, and any other relief that the court finds necessary. And oftentimes that's, again, tied to safety. So it's other relief the court finds necessary for the safety of the petitioner and children. But remember that economic relief enhances that safety. So if you don't have anything specific, think about whether or not you can use your catch-all section to provide this economic relief. And I'm going to go ahead and turn it over to Judge Tepper.
All right. I want to echo what Judge Aycock is saying is, look, you've made a determination there has been violence. of course we need to do whatever it would take to protect an individual, and we, within the confines of the law. We have to remember that just as we don't want to appear unbiased, we also don't want to appear biased because the parties had an intimate relationship. If a stranger was raped by an individual, we wouldn't hesitate to issue orders of stay away, orders of protection that were very complete. And so we should not be influenced by the fact that there had been an intimate relationship. And so, for instance, in a sexual assault case that has, for instance, a sexual assault protection order, or, for instance, if it was a criminal case, it's a very simple no-contact order. But to be more complete in a sexual assault case, it's not unusual, sadly, these days that they happen on high school campuses and on college campuses and even at the workplace. Therefore, any ex parte injunction or a final judgment needs to be specific and be sure that the court is not inadvertently, indirectly allowing the respondent or defendant in a criminal case to, in essence, drive that petitioner, that victim, away from where they are employed, where they're going to school. Because what happens is, if we're not specific, for instance, I enter orders, whether it's high school or a college campus, that say that the petitioner cannot be removed from their schedule, from their classes, without their consent. So that means if they were in the same lunch period or they're taking the same class on a college campus, it's the respondent who has to be moved, not the petitioner, because there is no reason that the petitioner, being a victim of a crime, a victim of a sexual assault or stalking, should be forced to give up any school credits partway through a semester if they leave because they're desperate and afraid, school aid, the support they may have from counselors in their school, any of their professors, their career. The money that they may earn in the future can be negatively impacted. And, of course, in deciding what restitution should be ordered in a criminal case, it's very simple in cases in where there's a lot of plea bargaining for a prosecutor to come into the court and say, Judge, we've agreed to such and such. A court, in order to be responsible, asks if there's restitution, and you're told there's $5,000 in restitution, and then you have to say, well, I see that this is a 1-year term of probation, and since probation needs to be paid off 60 days prior to the end of supervision so that probation has adequate time to file an affidavit of noncompliance, I need it paid off in 10 months. So you're telling me that it's realistic for $5,000 to be paid off in a specific monthly amount in 10 months? So perhaps the questions the court needs to be asking is, how much is the restitution? Have you found out, criminal defense attorney, how much your client can afford to pay on a monthly basis? Okay, let's do the math. $100, into $5,000. That's how many months plus 2 months, 60 days, that would be realistic. I can only approve a plea bargain that shows that it's going to be paid off in this manner, and if this seems like it's too long, I'm happy to put in a provision for early termination on satisfaction of restitution and all conditions, but no sooner than, for instance, if the state was negotiating for 12 months, but really 24 months is needed to pay it back. And, of course, it's very important to issue specific restitution orders saying when the amount shall start, any fees that are required, how much is to be paid. I believe that the court needs to have protocols, of course, in place. It needs to makes it clear that the probation office has an obligation to notify of failures to pay, that the individual, the victim who is getting repaid restitution, whether it's because they had windows broken as forms of entry, whether they had clothing ripped, whether they had phones broken, that they understand what they can do if there is not payment. And, of course, it is important to show that ask the prosecutor if they have determined if all forms of restitution have been considered, and if so, what is the most important issue? So, for instance, in a domestic violence injunction, I may have a phone that's been destroyed, and if I have a respondent that's consenting or I found that there is a basis, and there's been an admission, yes, I destroyed that phone, then I can turn and say, how much you think that phone is worth? $60. When can you pay that? And I'll get an answer, and then I'll make that part of the order. And, of course, another overlooked form of making somebody whole is in a protection order if they were, for instance, a girlfriend, boyfriend, and a car was removed against the petitioner's will that the respondent has no legal right to, they're not married, then the court in an ex parte as well as in a final judgment needs to make sure that law enforcement will assist in restoring the petitioner or a victim in a crime to that vehicle and the keys of the vehicle, any laptops, things like that, because unless they can produce a title that is in their name, I'll add that language just to be safe, the petitioner is entitled to have it restored from the get-go, from the issuance of the ex parte. And then in conclusion, another piece that I think is also overlooked is technology has increased. The electronic postings on any public media can be devastating. There are individuals that will post to humiliate. They will post about a petitioner, to the petitioner, or photos of a petitioner, appropriate, inappropriate. And so many people have public sites, and no matter how many times they block them, they're still out there. And employers see them, school administrators, future employers see them, and that's a form of humiliation. That's a form of cyber stalking, which in Florida, and I'm sure many states, is now illegal. Therefore, I insert, even though it's not in our Supreme Court form yet, I insert into ex partes and final judgments, they shall not do those things. And if there's already allegations in the petition that has happened, I will give them 8 hours from the time they are served to remove those postings. Another form of protection so they don't end up losing a job because of this cyberbullying and stalking.
And those are great practical steps that judges can take if they're aware of these kinds of connections between the economic issues and really how the courts can work and run. You've both kind of alluded to the importance of being specific and of awarding specific relief when it comes to economic issues. Can I ask Judge Aycock to maybe talk just a minute, and I know you both do this, to talk about review hearings and enforcement of these orders, because it's great if they get into the order initially, but if the court doesn't enforce it or if there isn't any a review hearing or periodic review of these things, they can simply go unheeded by the abuser, and the victim is left holding the bag, essentially.
Right. Review hearings are very important, and they increase accountability and compliance, which then ends up increasing safety. And the idea is that once you've ordered relief, whether it's economic or otherwise, and hopefully it includes economic relief, is that you have the respondent or the defendant come back on a regular basis and to show the court that they are, in fact, in compliance. Put the burden on the respondent or the defendant to make that showing. One of the things that it does is it reduces the number of show cause hearings or violation hearings, because once a batterer knows that you're watching, the court is watching, and that the court will, in fact, impose quick and sure sanctions, they're more likely to comply. And there is some research out there that shows that that's correct. And again, if you think about, if you put the burden on the petitioner or the victim in a criminal case, or the probation officer even, to bring these kinds of violations, first there's the time between when it happens and somebody realizes that it's a violation. It gets reported. There has to be notice sent out, and then you have to have a hearing. In the meantime, what's going on? And you don't know, and it may be continuing. So it's really important to have these review hearings. Batterers know that if you're making the rules and they're no longer making the rules, they'll comply. And don't make the victim be there for these review hearings. Again, put the burden on the respondent or the defendant to show that they are in compliance. And finally, I would just say that all stakeholders need to be on board in terms of enforcement, and that the stakeholders in the CCR agree that there need to be quick and sure consequences for violations.
I just wanted to add, all judges expect their orders to be obeyed, and this should be no exception. Failure to follow the court's orders in this case has potentially financially and personal devastating consequences on a victim. So we have a stake in seeing that our orders are complied with.
And what you raise also takes us into the next area to talk about what court staff and the justice system sectors can and should learn about to address survivors' economic needs, because usually probation, for example, is an arm of the court or is part of the court process. So as one of those coordinated community responders, probation needs to be on this. We've talked earlier about how law enforcement and prosecutors, we hope, will be bringing this up. And I want to take a moment and acknowledge a question that came in saying, all this is great. How do we get our judges to know this and to do this? So I want to just let you all maybe sprinkle that into your answers. Think about that, how you kind of get the word out about this. Clearly this whole webinar is about how to do this, and know that at the end maybe we can address this more fully, because Mallory is going to talk about the court's guide, which will again give you out there, advocates, court staff, others in the community, information about what courts, judges should do around this area. So know that hopefully by the end of this webinar we'll have addressed that fully. But judges, as you're going through this, you might want to think in particular about ways to motivate some of your colleagues on the bench to pay attention and to know what you know and to do what you do on focusing on safety and survivor security. So let's move to this next question, which is how other court staff and the justice system sectors learn about and address survivors' economic needs. Maybe Judge Tepper, if you'd like to talk a little bit about how you work with your case managers and judicial assistants about how to kind of further this, especially maybe around both getting orders crafted at the outset and enforcement.
Yes, I'm years ago when financially we had a case manager to assist. The case manager did this job, but as that money dried up, my judicial assistant learned how to do child support calculations. Our IT department many, many years ago created a very simple format where we can input what the income is, and of course on a domestic violence injunction, my judicial assistant gets from our domestic violence clerks each week a copy of the petition, a copy of any financial information, and I get a summary of the case and what they're seeking, so that it's always, I don't have to worry about handwriting, but she's calculating, and I can read the whole petition, but I'm just saying this case on reviews comes back, I can see it very quickly, how many kids, ages, but more importantly, she looks at the financial affidavit and puts in under our guidelines what their net income is, and when the respondent comes to court, I find out what the net income is if I'm issuing a final judgment, and we know what minimum wage is as it changes on a periodic basis, and we estimate that. We plug in the number of children. We have a place to plug in any daycare that is claimed. I can confirm with the respondent if they agree or disagree with that daycare. Any health insurance that under our state guidelines comes in different ways out of the calculation. And then I have a dollar amount, and of course I would have taken into consideration if a respondent's paying for another child, etc. And then I have room under the guidelines whether to go up, down, or whatever, but I have a one-page sheet that is emailed to me each week by my judicial assistant with each case number, and then I can pull it up and then I can modify it. If the testimony turns out differently, I save it on my desktop in the courtroom, and if the parties come back, I always have it there. That's for unrepresented individuals. Where individuals are represented, their attorneys, they're pretty well trained around here. They've come in with child support guidelines already calculated, and then I order it. In addition, you need to understand that periodically there may be some significant changes in circumstances, and just like Judge Aycock, I'm doing reviews or modifications. Those can be considered by the court. I think it's very important for judges to educate anybody that's doing survivor or victim provider services, the Prosecutors Association, any of the lawyers, the legal aid, and other judges to educate them on issues such as this, to understand what the law is and what we could do and how to do it better and more efficiently and have better outcomes. In addition, I believe we need to educate them on what is available for both sides, and that goes for sometimes people get arrested that shouldn't get arrested, and they're arrested, but it's dismissed. Nobody knows about expungements. I think they have a job to assist their clients in getting it expunged. I believe that credit histories are negatively impacted by what a batterer may have done as a form of control. They need to be educated on how they can solve their credit history. They need to know how they can file copies of criminal restitution orders or domestic violence injunctions to assist them. That's just some ideas I have, and I also do, by the way, income deduction orders in criminal cases and periodic reviews to make sure the money's really being paid, and our clerk on a monthly basis or however frequently I request will give me a listing in criminal cases or delinquency cases how much money each defendant or juvenile was ordered to pay in restitution and the status of it, so I can choose to set review hearings or orders to show cause.
And, Judge, you mentioned that, we have child support guidelines here in Florida, and there are probably other income kinds of guidelines like that around the country. But you also mentioned that there is room to move up or down, and I wanted to bring everyone's attention to the very beginning of this program where Mallory was talking about what it really costs to survive in various jurisdictions, and, again, refer everybody to WOW's resources, wowonline.org, because on there you can see the real costs of things, so that if a judge has any question or if an advocate wants to talk to the court about what the costs really are facing someone on a protection order or in other economic circumstances, there is really well done and well-researched, credible research that they can pull from WOW's work that will help them. So thank you. And Judge Aycock, do you want to talk a little bit about some of on the criminal side, maybe screeners, pretrial, probation, parole, any of those issues in terms of other court staff and what needs to be shared and learned about this issue?
Sure. First, it's important that everybody in the system knows DV. They need to be trained on the fundamentals and the nuances of domestic violence. And that judges, clerks, administrators, probation, parole, guardian ad litem, custody evaluators, lawyers, everybody that touches these cases needs to really, really understand domestic violence. And if you have screeners or pretrial intake, those people not only need to be trained about domestic violence, but they really need some specific training on economic needs and how that addresses survivor safety. And they must ask about finances. And so it's not just, do you have any money, but who controls the money? Who's paying the rent? Who's paying the insurance? All of those who's making the car payment? Who actually earns what in this relationship? When you have all of that kind of information, it's much easier then to advocate to the court about what needs to get done, whether that's during a pre-sentence investigation or whether that's during a release hearing. And it's important that this be an ongoing process. So you can't just take a snapshot of the needs, economic needs today. There really needs to be an ongoing, continuing check-in to see how the victim and if there are children are doing financially as well as safety. And then finally, people, court staff and justice system people need to know what the local resources are. What is actually available and out there? Just as an example, I'm on the board of our local DV shelter here in Reno, Nevada, and one of the things that we just recently learned is that that Charles Schwab has a program where they will help pay for victims of domestic violence housing costs. So we're trying to work with them now to help us actually pay half of the cost of the rent in transitional housing, so that when women leave, they can actually have some money saved up that they can use for a first, last, or just the regular monthly rent. And if you have, the advocates should be working with, like the court clerk's office, to put together a list of all of the resources in the community, and those should be available not only through the advocates, but they should be available either at the clerk's office or to actually be available in the courtroom.
That's a great idea. So that in case of say a survivor doesn't reach out to a domestic violence program or the Rape Crisis Center, those resources will be there. That might actually connect them to those community resources. So that's terrific. And I bet everybody's going to Google Charles Schwab as soon as we get off this webinar and see if similar programs are available in their jurisdictions. That's a great one. Thank you. All right, so let's move to the last slide, which is talking about really kind of pulling everything together on, and you've both alluded to this but let's talk maybe about some specific policy or structural changes. We've talked about some education and awareness, and I would add too, Judge Aycock, that a lot of folks don't understand a lot about stalking and all the implications around stalking and the costs associated with stalking victims, getting to the next steps and being able to heal from that. So maybe we can talk a little bit about some policy and structural changes. I know that Judge Tepper, you have a lot of good forms out there that you have already created that WOW is going to make available on its website that people listening to this call can certainly take, share, and adapt to their jurisdictions. So you want to talk a little bit about forms and maybe some scheduling issues?
Yes. From a civil perspective, on orders of protection, as Steve mentioned, the court is the one that's enforcing, not the petitioner. And when I order a batterer's intervention or I order child support, I have a form, and in Florida I can order substance abuse evaluation, mental health evaluations, again, trying to create protection so that there will be safety and somebody doesn't have to leave their job where they live. I have an order to appear, and then later it changes, but they have a time certain. I have them appear within usually 45 to 60 days at the most to show me that they're paying their support, that they're in a batterer's intervention, things like that. I will also periodically order that I need both parties there to review the safety factors involved in child parenting time. But with regard to the economic issues, I can't hold anybody in contempt, in my opinion, unless I get an affidavit from a petitioner failure to pay. But the respondent knows they're going to have to come and answer to me why they haven't been paying support. And then we're going to have a discussion about if I get an order to show cause, I'm potentially going to explain the impact of indirect civil contempt. I do want to make it clear, I saw a question on here, child support orders are not entered in criminal cases. However, a standard order in Florida law of probation is you shall support all your dependents. And when I sat on criminal bench, I used to make it very clear that I expected to know whether somebody else was behind in court-ordered child support, because that's a violation of your probation. You may not have them arrested, but I want affidavits filed if they're not paying their restitution, they're not paying their support, and the criminal judge can decide whether they're going to come in on an affidavit with or without an arrest. In addition, on the scheduling piece, the whole structure has to change in terms of who we're here to serve. That has tremendous economic impact. Steve touched upon that. We have a very bad habit as judges to think everybody's here to serve at our convenience. Not so. We're here to meet the consumer's needs. And that's why when I schedule matters, I'm finding out when we're coming back on these reviews, these orders to appear, what's going to work for the players. I don't want a respondent who's paying child support to miss a day's work to be here. I don't want to find out that children have to catch a bus or go to daycare at a certain hour, and I've said it, and it's impossible. So I make a brief inquiry on that to coordinate it. I do want to point out that the National Council of Juvenile and Family Court Judges awarded 6 sites in the United States. My area in Florida is a one-judge, one-family site called Project One, and part of that stands for equal and coordinated access to justice. Coordinating. So if I have a family law case that's going to be potentially setting temporary relief and a domestic violence review, I'm going to coordinate them on the same date so that neither party is going to lose money to come to court. I'm trying to make sure that it is accessible and it doesn't cost money. I try to also set time certain so they're not hanging out all day in court. Now I'll turn it over to Steve.
Great. We've got about a minute. I'm sorry, Steve, to wrap up as you can to talk about some structural changes.
Okay. Well, first, economic relief should become a policy of the court. And I know there was some questions here about, that's great, but how do we get our judges involved? And judicial leadership is vitally important. If judges call meetings and get and say we want to create a coordinated community response in our community, people will come when the judge asks people to come, especially if you provide food. But also, if there isn't any judicial leadership happening in your community, what can you do? Well, one of the things I advise advocates all the time is talk with the lawyers. If you have access to any of the judges off the bench, talk to them. Try to figure out who would be a champion if they were given the opportunity or the impetus to become a champion. And try to figure out how do we get that person then to get training, how do we get them, how do we talk to them on a regular basis so that they can see how important all of this is. And that can be both hard and intimidating for advocates to do, but that's why, if the Bar Association, if there's some attorneys in your town that get it, join up with them. Maybe create, if you haven't got a CCR, create a CCR without the court and then invite the court to come to the CCR so they can understand what it is you're doing around systems change rather than any particular case. Beyond that, it's if you have a grant, one of the OVW grants that allows you to take or send one of your judges to training, send them to training.
That's great. That's great. And you also had a good point, I remember in our prep when you were talking about sometimes economic relief is awarded as part of a catch-all. You mentioned that earlier in the call. As part of maybe an unwritten policy, some judges might have to do that. Well, try to get it into written policy. If there's something about what can be awarded and maybe it's not in the statute, you can have an individual policy within your court or jurisdiction that maybe that could be there. Or maybe you need to get forms changed at the state level.
Right, and all of the judges need to be on the same page because we know that judges rotate, that we have sometimes judges or commissioners or magistrates or referees, whatever you may call them, that are doing the temporary orders, and then the regular judge is actually doing the final order in a civil protection order. But they all need to be on board together and understand what it is that everybody is actually doing, so that they can take care of that problem and not have inconsistencies so that it doesn't end up on which judge did you get as to whether or not you got relief or not.
Exactly. Well, that's terrific, and I know that you have resources at NCJFCJ that we can talk about at the end of the call in terms of people getting, making suggestions on training and other kinds of help and support. So let me turn this now. Thank you both very much. That was a great discussion, and I'd like to turn this back over to Mallory.
Great. Thank you so much for that great discussion, Robin and Judges Aycock and Tepper. So we don't have a ton of time left, and I would like to be respectful of that. So very quickly, I would like to introduce the Court's Guide to Safety and Economic Security for Victims of Violence Against Women. So this is really to respond to all of the economic security needs of survivors and the role of courts that we've previously been discussing. It really goes in depth. It's a hands-on tool and a very accessible document that addresses one, why judges should incorporate economic considerations into their work, and lays out exactly how to do so using very user-friendly tools, policy recommendations, and training guidelines. So eventually this will all be part of a greater toolkit for the criminal justice system that can be accessed online. The Courts Guide is now available for free online. The link is down there at the bottom. It will also be sent out among the presentation materials that we're sending out later this week. So the Courts Guide was developed in consultation with leading experts from around the country, including current and former judges, and with regard to model policies and existing best practices. While it's designed primarily for judges, court staff, and judicial educators, it can also be a helpful resource for state stop administrators, others working in the criminal justice system, and advocates within the community, which kind of brings it back to the question we've been trying to weave throughout of how advocates especially can get those in their jurisdictions to consider these issues. A lot of this information can be distilled and presented and is great for both advocates and those in the system to be aware of. The first chapter really makes the case for why judges should be considering economic security and defines what it is, similar to some of the information that we presented at the top of this call. But the bulk of the Courts Guide really is dedicated to the second chapter, which explores in detail many of the ways in which judges and court staff can incorporate economic security into their responsibilities with any case. So it contains extensive checklists that give options for various scenarios, ranging from intake and pretrial considerations, such as release conditions and pleas that Judge Tepper and ACOG have mentioned before, to sentencing and review hearings. Additional chapters also examine the ways in which the court structure itself can impact survivors' economic security, how judges can benefit from and support the work of other system sectors, and the policies and protocols that may help to incorporate this into your jurisdictions. And lastly, there are a number of supplemental materials that can be used by a variety of audiences. For example, one of these sample tools is the judicial defense card that we've created around this. It's just a very concise 2 pages with very straightforward checklists and can be easily added to case materials. So those checklists include various economic-based crimes, evidence, intake questions, and sentencing-related questions and follow-up. So that is also available for download for free on our website. So in addition to the Courts Guide and the bench card that we've been discussing, there are a number of other economic security for survivors resources here online for the criminal justice system, including for the STOP grant program in general, the law enforcement and the law enforcement pocket guide, the prosecutor's guide, and the pocket guide that goes along with that sector. In addition, we are currently creating the Last of Our Sector Guide series, which will be for advocates both within the justice system and in the community. And lastly, I just want to plug that we here at WOW, we also do free technical assistance around this. So any advocates or court systems in communities, if you want to learn more about this issue and have us do any training or long-distance technical assistance work, please get in touch with me. I believe we're just about out of time, but I think we covered all of the questions that people have sent over the chat. So I will just go ahead and say, here is my contact information. We will be sending out all of the PowerPoint, the recording, and accompanying materials that we've been discussing today. And if you have any questions, please get in touch. A very huge thank you to Robin, Judge Tepper, and Judge ACOG for your time and the very valuable information that you shared today.
Thanks for inviting us.